Lord, I am appearing for the petitioner in this matter. My client has instructed not to proceed with the matter. 2 and 3, my lord. Lord, this is the letter
Matter is
received by the client.
appearing
May
on
it be
the
kept
heading
with
to
the
be
record.
mentioned.
Time for respondent private respondent number 629.
Mr. So and so, learned advocate for the petitioners, submits that the petitioners does not intend to proceed further with the instant writ petition. He files a written instruction dated 20th March 2025, which is taken on record. State.
I am for Jila
representing
Pursa.
here.
I am for Jila Pursa, my lord. Respond 2 and 3.
In view of the above, the writ petition stands dismissed as withdrawn.
Thank you.
All connected applications, if any, at the interim orders, you will have the answer.
My lord, letter may keep kept with the record. Grateful to you, lord.
Taken on record, Gurudev.
But I am for the added respondent in this matter, my lord.
72.
72.
Oh.
My lord, there was an interim order which was passed by a coordinate bench of this court, which was appealed against before the Honorable Division Bench. Appeal was preferred at the instance of my client. He was not made a party, though he was participant in respect of the tender. The appellate court was pleased to refuse my prayer to interfere in that order. However, appellate court directed me to be treated as a party in the writ petition. So this is the order of the appeal court, my lord. This is a matter related to tender. Mr. Jahan is appearing for the petitions, my lord.
I have already annexed this order in can 1, can 2. There's an application for my lord, extension as well as reimposition of my interim order. On and from page 11, I have annexed it.
Can 1.
Can 2. Can 1 by my learned friend for addition of party. In fact, that become infractious by order of the division bench.
Can 1 or can 2?
Can 2 is mine.
Can 2 তোমার
কি বলছো দাদা ভালো করে তাকিয়ে দেখো
এক্সটেনশনের জন্য
দেওয়া আছে দাদা এভিডেন্স সার্ভিস করে দেখো
সার্ভিস করেছি
তাই
Lord, I have Lord, in the main writ petition, Lord, this is my affidavit in opposition, Lord. I have served.
দাদা এটা কে নিয়েছে গো দাদা?
Can 2 I have not been served. Lord, the extension of interim order.
আপনার ক্লার্ক নিয়ে
What I have
26 জুন বেলা 12টার সময় আপনার ক্লার্ক রিসিভ করেছে
Actually, may I be permitted to, this is one of my suggestion, subject to correction, my lord. Since the matter relates to the tender, my lord, kindly ask the authority to produce the document
Yes,
since
I
it
will.
is coming for the hearing stage. So
or perhaps I am for the
Give me
petitioner and my lord others are vocal but I couldn't follow.
you should be vocal, sir.
Everybody should be.
You should avail this opportunity.
Once your lordship go through the order of the division bench, certain point has already been settled there.
দিয়েছি
Any direction was given in the by the division bench to file affidavit in opposition?
Affidavit in opposition direction that was by the single bench itself.
Only upon the state response. Only upon
That I have filed well today. And I believe I have served.
Okay.
17th June order by the coordinate bench.
A copy may be
In this
given to us.
read
We can also.
What is the prayer in Can 2?
Or can 2 order for extension of the interim order, which was passed on 17th of June, because that was till 23rd of June. Now, in between, my lord, the appeal was preferred.
Okay.
Now, the appeal dismissed.
Later date.
Can
Speak
1
for
is
hearing.
for,
Can 1 for one addition of party.
that is,
There are certain advancement in this so far this proceeding is concerned, and my learned junior is insisting me to place this. Lordship, so far this auction in respect of the second notice is concerned, the auction has already been held on 19 June 2025, where my client, who has been placed as serial number third bidder. Now, third bidder, that is one Rajiv Mondol. First bidder quoted 78 lakh 20,000, second bidder quoted 78 lakhs, and third bidder quoted 77 lakhs 60,000. This is the quotations given. This is the update which is already there. So, Lordship, kindly.
no, as on date, the extension is allowed, right?
Right.
Now you intend to file any opposition to the writ petition?
Lordship, yes, my lord, provided I'm given a chance to do so, Lordship, in that case. If your Lordship wants
By
to.
such order, you have been added as a party, so your application, no order needs to be passed in Can 1.
That has become infructuous, my lord.
Awesome.
Later date.
Affidavit in opposition
Later
filed.
date be fixed for hearing, my lord.
Huh?
Later date be fixed for hearing, my lord.
Affidavit in
Tender
opposition
relates to
filed on
the
behalf of
public work.
respond number 1 and 3 is taken on record, copy served.
Or
Can 1 of 2025,
can 2 affidavit of service I am filing.
Can 1 of 2025, this is an application for addition of party. By order dated 17 June 2025. Sorry, না 17 June. Math হচ্ছে 24 June 2025. The intervener, applicant intervener, has been allowed to be added as a party respondent in Can 1 of 2025 arising out of MAT 912 of 2025. Let such addition of the applicant be made in terms of order passed in MAT 912 of 2025 by the Honorable Division Bench. Accordingly, the application for addition of party Can 1 of 2025 has become infructuous.
An order is to be
The
passed,
only
or
one
an order
thing-
is to be passed upon the petitioner to include him in the cost title, because the cost title needs to be amended accordingly.
That-
Department is directed to, or you, I am granting you leave, you.
That is to be done by
Sir,
my
it's
client.
granted- Leave is granted to the petitioner to incorporate the applicant intervener in the cost title of the writ petition. Can 2. This is an application for extension and or restoration of interim order dated 17 June 2025. Mr. Sarvar Jan, learned advocate for the petitioner. Affidavit of service. Seeks for extension of extension when it has expired on 23rd.
23rd of
Seeks for restoration of the interim order. He submits a restoration. The order dated 17th June 2025 was passed, staying the e-auction number 004/06/2025/NAUDA/PS till 23rd June 2025. The said order was appealed before the Honorable Division Bench in MAT 912 of 2025. The appeal has been dismissed. Affirming the order dated 17th June 2025 passed in the present writ petition. Accordingly, the interim order granted till 23rd June 2025 is reimposed and extended till when can you file the affidavit of opposition?
Lordship, 1 week, Lordship.
1 week.
Lordship, may I only
The-
submit one thing, Lordship? This is one concern which has come to my mind, is that till the interim order is passed, that no finalization of tender will be done. That is the interim order which has been affirmed by the Honorable Division Bench. My Lord, after this order is passed, substantial period of time is over. My Lord, kindly your Lordship observe that who is running the ghat presently. It should be in the custody of the Panchayat Samiti, my Lord. That otherwise the status quo would be altered. Let the status quo be
But I
remain as
fail
on
to
today.
understand what submission my learned friend is doing. He is a mere participant in the tender process. Now, tender process has not
Yes.
yet been finalized.
is extended till the what you call the in end of July 2025 or until further orders, whichever is earlier. Added respondent. What is your name?
My name
Added
is
respondent.
MD Rejaul Haq.
Rejaul Haq.
Granted liberty to file affidavit in opposition to the writ petition within a period of 1 week. Advance copy of such affidavit in opposition is served upon learned advocate for the petitioner. A reply, if any, be filed within a week thereafter. Please this matter after 2 weeks under the heading returnable motion. 2 সপ্তাহ পরে ডেট বলুন। Can dispose. 14. July.
In the meantime, possession should not be handed over, Lordship. That is another thing.
It has not been finalized. The tender has not yet been
So you were
finalized.
not there.
So
You
where
were
all
not
these
there.
questions are
I'm just
coming?
referring from your
Questions,
writ
sir.
On
petition.
behalf of an added respondent,
I mean, added respondents, we have equal right now.
How can it be done if the finalization is not done?
So, Lordship, let it be submitted by the Panchayat.
Court has granted stay till 23rd. That has been reimposed. So if there is no finalization, how can it be handed
So
over?
it cannot be
trying to
handed.
secure an order in my writ petition.
That should be secured
No.
by them. The Panchayat Samiti should be.
Further clarification is required because while granting
Let the
stay
Panchayat.
till
This means
something happened, you come.
kindly
Extremely
return.
grateful.
I have filed below my affidavit in
If there
opposition.
is any other steps taken by them, you come up before this court.
Then I have filed my affidavit in opposition. That should be taken on record.
All right.
Grateful.
None appears again.
Madam, for the state.
Yeah, for the petition.
No.
Yes.
For the petition, Lordship, on the last occasion, your Lordship granted a leave to amend the cost title. The Pradhan, name of the Pradhan was wrongly mentioned. So I have subsequently amended the writ petition and the CAN application and sent the copies, amended copies.
Affidavit.
My lord, this is my instruction from the police. My lord,
Affidavit of
I have no role to play, my lord. Pradhan is the answerable authority.
Affidavit of service.
Affidavit of service. This is here it is showing dispatch.
Affidavit of service filed on behalf of the petitioner is taken on record. Can 1 and can 2 has been disposed of.
No, no, Lordship.
What is can 1?
CAN 1 is a restoration application and CAN 2 is Section 5 application. Until
While it is found that
Pradhan
service
Pradhan.
has not yet been effected, learned advocate for the petition is ready to serve afresh upon the added respondents. Other respondents have been served.
His Lordship. The private respondent last occasion appeared also.
Serve afresh upon the added respondents while affidavit of service on the returnable date. Is this matter? 2 weeks. Follow করতো না যে
মানে my report में
মোশন এস হেডিং এ বলেছিলাম অ্যাপ্লিকেশন এসছে কেন?
মানে I have filed my report on behalf of the
Report
police.
filed by the state is taken on record. Let the service be completed after that. Will take.
My lord.
Okay. Lordship, can two dispose of or not?
Without service, how can this be heard?
দাদা জিজ্ঞেস করো দিতে বলেছে
Disposable, ঠিকই আছে, মোশন ভুল করেছিলাম ওটা। Under the heading applications.
Integration.
হয়নি এখনো।
Dispose of.
Both the applications are pending.
Yes, Lordship.
You complete the service and then. Application আন্ডারই আসবে।
What?
I'm grateful, my lord.
My lord, I am for the writ petitioner, my lord.
74, I be for the state, led by Mr. Sam.
My lord, this is the matter relates to the compassionate appointment. And my lord, last date of hearing, my learned friend produced the report on behalf of the department where they came to the conclusion that my application or my prayer turned down because of the reason, the ground of delay, that is 9 years delay. My lord, the incumbent, my lord, the father of the petitioner died in the year 2006, that is 8 January 2006. And I made application 7th February 2006. That is within the time. Within 1 month, I have applied before the authority. And my lord, the record shows that is Annexure P4, page 23. My prayer was forwarded to the PPRD.
Prior to my learned friend submissions, if I may help the court in recollecting what happened. The writ petition was heard. I was directed to file a report. My report said that his prayer has been considered and rejected due to delay filing of application. Your lordship was of the opinion that the matter should be disposed of as because a new cause of action has arisen. No liberty was given to him to take out any exception to the report. That would reflect from the order. Today, whatever my learned friend is submitting is in respect of the subsequent development. He is contradicting the report. In that case, he'll have to challenge the report, your lordship.
My lord, in court can proceed with this writ petition because of the reason the prayer is the same, and prayer only it can be done that this the report which has been submitted before that it can be supplemented by way of supplementary affidavit, and otherwise the grounds and the prayer is same of the writ petition, so the court can proceed with this present writ petition.
Then appropriate application or submission in that respect
Yes,
has
yes.
to be made, your lordship.
That
hasn't yet been made. And one more thing, which I have pointed out on the last occasion, the annexure P2 that my petitioner is banking upon is an unsigned and an unverified form that he has annexed with the writ petition.
This is my
But in respect, please let me complete.
sorry.
In respect of the report that I have submitted before the court, that has got the completely received format, which shows that it was received only in 15 July 2015.
My lord, record shows.
This is also part of the record. This has come from a government
Yes.
official.
Yes, that is the different story. My lord, annexure P2, that is
So those stories have
based-
to be
yes,
incorporated
yes.
in a different writ petition.
because my application was in the year 2006. In the meantime, when the department is taking decisions, that is in the year 2023. That is in the year 2013, new notification has come. So in terms of that notification, the pending case have to be disposed of. Well, record shows that 2006, I applied in the prescribed form for compassionate appointment, and that application forwarded block development officer to the DPRD on 6/6/2006. Please kindly come to page 22.
No pagination.
And DPRD also requested Deputy Director inquire into the matter. That is page 23, P4. So how the questions comes that I have applied for the after 9 years in the year 2015?
Your Lordship, these are disputed question of facts. If your Lordship can, though I am not being able to refer to any page marks because my writ petition which I have been served upon is without any pagination. Just after the application form and after the letter that my learned friend is referring at annexure P3, the very next to next page is an affidavit which is affirmed in 2015.
Yes.
In my humble understanding, going out of my instructions, I may submit that it seems from the face of the records that there have been two applications.
Well, again,
Most probably one which my learned friend's clients have not proceeded with. And the one in respect of which my instructions are in respect of the 2015 application, which is there. Then this application has not been submitted by my learned friend's client, which has been received in 2015 with her photograph. And the application which my learned friend has annexed in the writ petition, learned friend's client have annexed in the writ petition, it is an incomplete form, no photographs, nothing, no receipt, nothing of any government authorities.
Well,
so now, if my learned friend wants this court to go into disputed question of facts, that it will be difficult for us to assess this court.
Well, there is no disputed question of fact. In terms of 2000 notification, this affidavit is required. In terms of earlier notification, this was not required. So that's why in the year 2006, I applied for the in the prescribed form. And when the 2013 notification came into, this affidavit required to be submitted because my case was pending till since 2006. That is why this affidavit is done in the year 2015 in terms of 2013 notification.
13, there was no such provision that
Prior to 13.
Huh?
Prior to 13 notification, there is no such provision to submit this type of affidavit.
after 13 they are
Yes. And the confusion is this, my lord, during this period, this filing this affidavit, I was given understand that I have to submit another form, which is my learned friend showing before this court. And at that time, I signed the second application, that is, my lord.
33.
Yes.
33.
So, my lord, it is no
There are
doubt.
two applications. That would be, again, there is no pagination. P6, there is a letter to the block development officer by the Mithu Boidya Sada. If I may place the last two paragraphs. আপনার নিকট আমার বিনীত নিবেদন এই যে আমি এই শর্তে স্বীকার ও অঙ্গীকার করিতেছি যে আমার মৃত পিতার অকাল মৃত্যুর জন্য আমি কোনোদিন চাকরি পাইনি, তাহা হলে আমার মা, বোন ও ছোট ভাই এর ভরণ পোষণ পড়াশুনোর দায়িত্ব পালন করিব। প্রকাশ থাকে যে গত 30/1/2006 তারিখে যে আবেদন করেছিলাম তার সুফল আজও পাই নাই। আমার একান্ত অনুরোধ, যদি আমি গ্রাম পঞ্চায়েতের কোন স্তরে কাজ করতে পারি আমাদের পরিবার বিশেষভাবে উপকৃত হইবে।
So again,
the confusion has been created by the nowhere in the petitioner it has been stated that he has been directed by the authorities to submit a subsequent application, because this report has been prepared in respect of his application made in 2015, which tantamounts that it was a 9-year delayed application.
Again, my lord, it is clear.
The report is wrong. How could they say so?
Because of this form, your lordship. The moment this form is submitted in 2015,
there is an official letter at page 22 of the writ petition. See?
Lordship,
Then
that I have seen.
That is silent about 6/6/2006.
Your lordship, this is in
Submission of
respect
prayer
of
by Mithu Sardar. So
Not-
there was a prayer.
So if for the sake of argument it is to be agreed, then this application is being banged upon by some of the letters of the authorities. That is at page just after the affidavit page and the certificate of death. This is a unreceived form annexed with the writ petition. Now the first thing which has come into the eyes of the authorities
Control
is this thing,
Page
Your
22.
Lordship.
If you have not received the application, then how could you forward it to district panchayat office?
Lordship, that is not my point. When the report is being prepared, we are seeing the writ petition. There are certain communications in this respect, but this application is itself incomplete. When the record is being searched in respect of the writ petitioner, this form is available to their record because the confusion has been created by the multiplicity of actions of the petitioner.
Then what about 6/6/2006?
Lordship, that has been there, but the petitioner has itself admitted that since 2006 we haven't proceeded. In 15, what my learned friend just now submitted, that he was advised to do so. That has not been the case in the writ petition. He has made a fresh application in 2015. Now, if a fresh application is being placed in 2015, a government authority will not go for searching litigation records. This writ petition has been pending since 2 years or 3 years. When this application has been traced out, it is a 2015 application. Then this has to be considered. He will have to make specific prayers that find your findings or pass orders in respect of my 2006 prayers.
So that should be considered.
If that is the direction, that may be considered and disposed of, Your Lordship. Or a detailed representation may be made in this regard.
But in that event, you have to come up with that report or affidavit, whatever, by stating that your state authorities has not taken any decision with regard to 2006 application.
In that respect, it is vacant, Your Lordship. In that respect, if this is the recent development, then in respect of 2006, we need to seek fresh instructions, Your Lordship.
Correct.
Kindly sees into it. This application has been made way back in 2006.
Yes, that is required.
Lot
within
of
time.
water has passed through the Ganges in the last 19 years.
So department is answerable. Why this application is pending so long?
No, this ought not have happened if the multiplicity of applications wasn't there.
This is not a question of multiplicity of
This is
application.
the same format submitted by you. It could have been a reminder or a recommendation, but that hasn't been so. The entire process has been started by the petitioner afresh, which hits the technicality of this 9 years or 3 months or 6 months compassionate appointment restrictions.
But then you cannot deny that 2006 he took steps, he filed an application.
Your Lordship, in that respect, I cannot submit from the bar. I'll have to seek fresh instructions in respect of the 2006
Yes.
scenario altogether.
If there is a 2006 application, then there is no question of 2015. What is the decision taken by the state authorities with regard to 2006?
Not sure.
The admitted position that they have forwarded it.
Not sure.
Ashun? By Monday, you filed your report with regard to this application.
Not sure.
If no action has been taken, then you will be directed to take action. Mr. Franso Learned Advocate for the petitioner submits that the petitioner initially filed an application in the year 2006. On which date? What is the date of your application?
It's my lord, 7 February 2006.
On 7th February 2006. However, till date, no steps has been taken. For compassionate appointment. However, till date, no steps has been taken by the state authorities. Subsequent thereto, as per the advice of the state authorities, on which date? In 15, which date you have filed your application? In 2015?
The
my lord.
application received in 15 July 2015.
as per
15 July 15.
advice of the state authorities, the petitioner on কবে বললো?
15 July.
On 15 July 2015 submitted another application. There is no delay in filing application. Rather, the state authorities have sat over the matter in providing compassionate appointment to the petitioner. Mr. Tanvir J. Mondol, learned advocate for state respondent, submits that there is delay of 9 years. Therefore, the state authorities, it has been rejected. 15 application
Yes, rejected.
eventually rejected the application of the petitioner for compassionate ground on such ground of delay of 9 years from the death of the employee. State is directed to furnish a report with regard to the fate of the application of the petitioner dated 17th 7th
February 2006.
6 positively on the next date fixed. Place this matter on 7th. 23 matter the 7th July.
My lord.
This is an application praying for illegal removal of illegal construction shop, my lord, in front of the
Here for the state
petitioner's building premises.
affidavit of service.
Yes, my lord.
Where
And
is
for the
your
petition.
affidavit of service?
Yes, my lord.
Second page, available record, APS square for that the approved petitioner have not filed any complaint. But GD number and agree, yes, till date about the incident. But no being asked, the petitioner also told that they have not lost any complaint of PS related to the matter.
এদিকে মেনটেনিং এসছে service has not been affected.
My lord, service has it has been sent by post and speed post and
Speed post.
yes, my lord.
Where is the track consignment report?
My lord, it is in the service, my lord.
এখন
সার্ভিসের ভেতরে আছে,
হ্যাঁ।
একটু দেখুন।
এটা দিন ওনাকে Learned advocate for the petitioner seeks accommodation to file affidavit of service. Please this matter.
এটা ছিল না এখানে আছে my lord, my lord, it is in the annexure, my lord.
You have to annex it with the affidavit, no? File a fresh affidavit annexing the track consignment report on Monday. Monday the report. 7th July. আপনাকে দিয়ে দিই।
এটা একবারে annexure.
কবে দেখবি? কবে দেখবি?
Affidavit of service.
এটা কি ফার্স্ট টাইম হলো? এটা কি ফার্স্ট টাইম?
না না, একবার আরো হয়েছে প্রাইভেট
Sir,
রেসপন্ডেন্ট কে সার্ভিস করার জন্য হ্যাঁ অ্যাফিডেভিট অফ সার্ভিস ফাইল করেছি।
বলার আছে।
Yes.
Page 94 is my grievance. After the elections were over, in the selection process of Pradhan and Upo Pradhan, this pandemonium happened.
94 আমার কাছে তো 87 পর্যন্ত আছে। তালিকা পিটিশনের কপি কি করে?
87
But we have no 94 page.
served with copies which have page number 87, which is the last page. দেখো দেখো না, এটা আছে কিন্তু ওর পরে নাই না।
It is informed by the learned advocate for the state as well as respondent,
State Election Commission.
State Election Commission,
And I am for the state valid.
that the annexures to the writ petition served upon them is incomplete. Learned advocate for the petitioner is directed to serve complete annexures upon the state respondents as well as respondent State Election Commission by in the course of the day,
Course of the department.
By tomorrow.
by tomorrow. And list this matter on Monday. Monday. Great. Upon affidavit of service. Upon affidavit of service.
নামটা আচ্ছা ঠিক আছে পেয়ে গেছি।
Lord, I beg to upon behalf of petitioner lordship. Consisted panchayat election law that was held on 8 July 2023 and 11 counting was held. But in the court cases, lordship, the ruling party have and their hooligans have totally massacred the entire system. And the polling agent of the petitioner along with the counting agent had been driven away. The entire matter was brought to the notice of the authority concerned, but till date nothing has been done. But the petitioner have already won 800 votes. Till date, the certificate has not been issued in the name of the petitioner.
Who will issue the certificate?
Lord, at that point of time, Lord, the district magistrate was the observer. The entire matter has been brought to the notice. The CCTV, if my lordship calls for the CCTV, it will come up that they have unleashed the reign of terror in the polling booth along with the counting station lordship.
আপনি স্টেট ইলেকশন কমিশন
The petitioner was assaulted also.
And his counting agent was also assaulted.
Affidavit. Sir,
No,
who is for the state?
I am for the state.
Election Commission की तो आमी copy पाई नहीं. I appear for Election Commission.
State Election Commission.
One humble indulgence, Your Lordship. I do not know whether the petitioner has made the State Election Commission a party or not,
Yes.
but I usually appear on behalf of the Election Commission. If Lordship directs, I can appear in this matter because
You have been made a party. Respond number 2 and 3.
been served a copy, Your Lordship.
Then
Lord, earlier date, Lord, I have found the affidavit of service, Lord. I don't have the affidavit of service. I think.
If you can serve me a fresh copy.
Lordship, please.
2 and 3.
That's for number 3, Lord.
Deliver.
Complaint is on page number 14. And representation is on page number 15.
You have been delivered. The office, it has been delivered to the office.
But somehow, Your Lordship, I have not received a copy. If my learned friend,
My Lord, if my Lordship is
if Lordship directs, he may serve. Good. আমি দিয়ে দিচ্ছি.
Miss Sonal Sinha, learned advocate, submit that the copy of the writ petition representing respond number 2 and 3. Admits that the copy of the writ petition has not been served upon her. Learned advocate for the petitioner undertakes to serve copy of the writ petition along with annexures. Miss Sinha, learned advocate representing respond number 2 and 3. Today you will give it?
Yes.
In the course of the day. List is matter. The other respondents are being represented by the state.
No, Your Lordship, the returned candidate, I don't know whether he has made him a party or not.
Oh.
Because
Who
since
is the
his
returned candidate?
yes,
What is the name of returned candidate?
আপনি returned candidate কে আপনি তো বলছেন unleashing of terror and certificate
that has been
you have made তো? ঠিক আছে.
Lord, the complaint has been made before the authority concerned.
Against whom? He is a private. He is
Yes.
contested the election. Who is this person? Who is the person?
Not a single person, Lord. There is a group. Lord, entered into the election booth, entered into the counting booth.
Miss Sinha, you
Yes.
go through the petition
Yes,
and the annexures and make your
Yes,
submissions
I
on the
will.
returnable date.
Yes,
If required, if any additional parties to be made, we'll
Yes.
do that.
I will also find out from the office as to who is the returned candidate in this constituency.
Sir, there is also a criminal cases against those parties.
Yes.
Who are those
What is
parties?
the fate of that? I find out.
Nothing they have done, my Lord. Nothing. They have thrown away. Lord, only it can be.
Matter on দিলে তো মানডে তারিখে আমি 23rd কি মানডে থেকে শুরু আছে কি মানডে
Monday.
Grateful.
Grateful, Your Lordship.
Yes.
Number 78.
78, well, I am for the petitioner, my lord. Lord, my affidavit of service, my lord, has been misplaced. But the state government learned advocate is appearing before your lordship. But the fact remains, my lord, I have challenged the region order which was passed by the block development officer. But in the region order, some contradiction between two officers. The block development officer issued a notice 2021. He admitted that the petitioner had discharged his duty above 240 days. The recent incumbent, the video that denied this and issued a memo number, they know he has not complete 240 days. So, my lord, I am praying before your lordship, one affidavit should be passed because should be filed because the two contradiction order passed by the video. One video recommended me and another video, my lord, contradicted in the earlier video order.
The recommendation?
Recommendation. Your lordship can see the region order. Very effective order, my lord. Can you see 146?
Where is the earlier order?
Earlier order mean, my lord?
You say that earlier video has passed an order in your favor?
Yes, my lord.
Kindly come page 147, Lordship. Kindly come in the petition copy, Lordship. And this is a report from video, Lordship. Contact. Second page of the report, Lordship.
147.
Rationale behind the order. May I read, Lordship? The applicant was engaged as a casual worker by way of resolution of the Kantai 3 Panchayat Samiti. Inverted comma, it is hereby certified that Sri Naru Gopal Das was engaged in this office for the very first time in the Panchayat Samiti establishment as a casual worker from 1st December 2002 to 29th January 2003. This post is not sanctioned vacant post under RD or PRI setup. It is by hereby certified that Sri Narugopal Thara was engaged in this office and Panchayat Samiti establishment as a casual worker on 15 January 2008 to till date as a casual worker. This post is not sanctioned vacant post under RD or PRI setup. It is to be added here that the aforesaid memorandum is the original memorandum and geo number such and such dated 16 September 2011 supplements the original memorandum such and such dated 23rd April 2010, where it has been mentioned that after careful consideration of the matter, the governor has now been pleased to order that these casual / daily rated workers who are remaining attached to various establishments of the government departments / directorates / regional offices for not less than 10 years as on 1st April 2010. It transpired from the letter bearing memo number such and such dated 20th December 22 issued by the BDO Contai 3 that the writ petitioner did not complete, Lordship, kindly come. This line, Lordship, did not complete 10 years of continuous service as on date as mentioned in memorandum number such and such, Kolkata, the 23rd April 2010. Okay, Lordship. Now kindly come, Lordship, in the report of the video, second page of the report, Lordship. Was engaged as a casual worker from 1st December 2002 to 29th December 2003, which is sanctioned vacant post under RD or PRI setup. And last paragraph, Lordship, in context of the aforementioned fact, it may be mentioned that a letter issued by the Joint Secretary P and RD Government of West Bengal, memo number such and such dated 30th January 23, which rejected the claim of the petitioner, Sri Naru Gopal Dhara. As he is a casual worker, not completed 10 years. So he is not suitable for the vacant post, Lordship. This is the report of the video of the contact. Now, Lordship, I will leave it to your Lordship. What will be the decision? I will comply with the order. He is a casual worker.
Where is the notification?
What, Lordship?
Notification dated 16 September 2011. You have annexed?
Yes.
Follow.
What is his prayer?
This is the report of the video, Lordship.
Well, I'm coming to this, my lord. Your lordship kindly asked me, just now your lordship asked me the question that whether did they sanction post or not. Kindly see page 106. Regarding the certificate is concerned. This is to certify that Narugopal Dhara, late Sri Sidor Dhara, Shishir Dhara, Manita, such has been working since 1st December 2002 as a casual worker for performing all official duties till 29 January 2003, and thereafter from 30th January 2003 to 15 January 2009, he has engaged by the then Block Development Officer Contact 3 to function as a Darwan cum night guard against the sanctioned post on a casual basis. So, Mala, it is a admitted fact he was appointed as a sanctioned post. But the next page, you'll also kindly see.
Worker, he is.
Yes, but next page, you'll also kindly see page 109. The block development officer wrote a letter to the Additional Secretary, Government of West Bengal, Panchayat and Rural Development. You'll also kindly see 109. So it reveals that now the present video defy all the memos issued by the then block development officer. And I have completed 240 days in a year. That was also certified by the block development officer in his letter.
What benefit you will get?
I am saying that my service should be regularized.
But he didn't complete 10 years of service, Lordship. How can it be, Lordship?
But in hidden video, you'll also kindly see the
Casual worker from
142.
2002 to 29 December 2003.
Kindly see page 142. The number of days service in a year, 240 days. So, I am asking myself, how the government officer defy the then predecessor in interest, it is a memo number. It is very funny, my lord. It reveals from the region order. Kindly see the, my lord, page 146, middle portion. Once the then video issued a letter that he is a sanctioned post, and my lord, now the present incumbent come to a conclusion that it is not a sanctioned post.
Where is your letter of appointment?
Letter of appointment, well, kindly see page 37, my lord.
It should be This is for the first time the writ petition has been filed.
No, earlier, my lord, I have filed, in pursuant to direction was made by the my lord Justice Sampa Sarkar.
Where is that order?
My lord, kindly see 115, page 115. My lord, kindly see 113, sorry, 113. 113, my lord. On the basis of that, Now the rigid order challenge before your lordship.
And the notification dated 6 September 2011.
6 December.
6 September.
6 September 2011. The application, madam.
Notification.
Yes, yes. Name was not my lord. Let me enclose the lord. On page 39.
তো বললো 7
9.
9 হ্যাঁ
Date of in person. September notification.
6 September, no? July 2039.
এই তো খুলে
Hmm?
সেপ্টেম্বর পরে হবে
দেখো তো 6 সেপ্টেম্বরটা কোথায় আছে?
এটাই তো দেখছি আকাশটার পর মেঘ কাজ করে লাগাইনি
না না আছে। ওটা লাগানো নেই মনে হচ্ছে। ঘরে 4/7/2023।
ইয়ে করে
The 6th September notification, perhaps my lord, I have not enclosed. Your lordship give me chance to file supplementary affidavit, then because perhaps it has been not.
That is the notification on the basis of which you pray
Yes,
your
yes.
enhancement or regularization.
Yes, yes, yes.
And that has not been annexed.
That has not been annexed, I think, my lord. Your lordship give me chance to file.
To annexure P5.
P5, page 43.
Yes. There was a proposal for enhancement of remuneration of casual workers.
Yes.
At that point of time, the Joint Secretary has called for a certificate from the BDO whether the post of sanctioned vacant, that post is against a sanctioned vacant post. And there are other paraphernalia and formalities which has been mentioned in that annexure.
Yes, sir.
Just find out what is the report submitted by the concerned district magistrate to the Joint Secretary.
Only.
Page 43.
This will be because you say that as per the notification, there are twin conditions. One he has to cover 10 years.
10 years.
And each year he has to complete 240 days.
Yes,
Then
sir.
he is entitled to have that remuneration.
But he
On the
didn't
ground that he has not completed 10 years,
Yes.
that's why
He is
his
not eligible
prayer was
for
turned
the
down.
vacant post.
Okay.
This is the report of the video.
This is incomplete report.
With the earlier video, my lord, submit report that he has sanctioned and he has.
Learned advocate for the petitioner submits that. Oh, the petitioner completed 240 days of attendance. Yet he was not granted the benefit under notification under GO number 9008-F within bracket P dated 16 September 2011. And his prayer was rejected by the Joint Secretary to the Government of West Bengal, P&RD Department. He seeks liberty to leave to file supplementary affidavit annexing the relevant notification. Be granted. Let such supplementary affidavit be filed by the returnable date. Will you filing an affidavit in opposition or report in the form of affidavit?
Report in the form of affidavit.
One copy should be served upon me.
Okay.
State is
হ্যাঁ
that
নাহলে আমি জানবো কি করে কি আছে না আছে
files a report in the form of affidavit. Disclosing whether the petitioner has been engaged against a sanctioned vacant post submit report in terms of annexure P5. All these points. in the form of affidavit within a period of 1 week.
1 week, 2 weeks.
Within a period of 2 weeks, it will take. Period 2 weeks. Place this matter after 2 weeks under the heading written able
Lordship, 2 weeks. Wait, Lordship.
report দেবে তো exception 1 week after 3 weeks. Written able motion চলে যাবে। Okay.
Report may be kept on record, Lordship.
এটা report
One submission for your lordship, the report which was submitted for your lordship, one copy be sir.
give a copy. The report submitted by the state taken on record, copy served.
Get full lordship.
Next.
A 17-year-old I'm a state respondent. Several times petitioner is not appearing, well. Several times they are saying service not completed. Matter has been filed in 2023. And here, my lord, kindly see.
It appears on behalf of the petitioner.
They did not make the private respondent party in the writ petition, ma'am. Kindly. The constable, ma'am. They are raising complaint against the private respondent.
Not any accommodation has been sought for. View of the above, the writ petition is dismissed for default. Dismissed.
Deep down. Item number 79.
হবে তো 80 হবে তো হ্যাঁ 80 লর্ডশিপ I appear on behalf of the petitioner. This is my lord the affidavit of service. Matter relating to my lord the encroachment of the land by the my lord Panchayat authority.
I'm for the state.
My lord, page my lord the 64 is the complaint lodged by the petitioner, and petitioner is the recorded owner of the land, and thereafter there was an embankment that is my lord the extended and by the Panchayat authority, so that my lord my land has been encroached by the Panchayat authority without any acquisition proceeding. This is my lord the case.
Oh. Yes.
Yes, bolun. Apni bolun.
My lord, I find from the record, my lord, this is solely the answering respondent is the municipal Panchayat authority, my lord, not the state.
Let the report, my lord, call for from the concerned BLRO to identify the plot of land, whether the encroachment had been done by the Panchayat authority or
With
not.
regard to encroachment, they must have to file a civil
No,
proceeding.
this
Yes,
is
yes,
this is not the private dispute. This is only there is no private party over here. This is only against the Panchayat authority. You are representing on behalf of the state.
Don't advise me for whom I am repenting or not. Don't advise me on that. There was a previous writ petition where similar type of prayer was made.
Give the copy.
My learned friend Pradesh is not aware of that, my lord. The same person filed a writ petition being number 2191986 of 2023.
Okay.
Similar type of prayer was there. May I read out the prayer for your lordship? A writ in the nature of such a commanded respondent to forthwith certify or transmit all records and proceedings relating to their inaction, provide information under right to information relating to impugn remark the police doctor kortik.
That is different. This is my lord.
What made you laughing? I don't know.
Why are you submitting police doctor kortik? This is matter police.
Sir, this is the writ petition filed by the writ petitioner himself in the 2023.
This is well a different, my lord.
No,
They
no,
have
not a
been
different.
different chapter.
No, not a different one.
No. Police doctor.
Then go on running commentaries.
What was their prayer in the earlier writ petition?
In the earlier writ petition, they sought for an RTI with regard to the remark in their ROR that police doctor kortik rokhito. That was the remark in the ROR. They sought for information with regard to that.
Okay.
And my lord, they made a representation to the authority concerned on 15/3/2023 with regard to that, my lord. Thereafter, subsequently, this writ petition has been filed, remove the encroachment from the private land of the petitioner and to pay him adequate compensation.
But it was his knowledge, within his knowledge that it was the ROR reflects that police Daptar Koti Rokkito, he made the representation, all these travel into this court in another writ petition. The fate of the writ petition, petitioner must be aware of that. The same writ petitioner with the same style of cause of action and same prayer, almost in the same manner. That to be brought into the knowledge of the court, my lord. That has been specifically suppressed here. Yes.
My lord, there is, my lord, my learned friend is submitting, my lord, the regarding the this writ petition is not this separate, this one, it is not barred by any res judicata or like that. They have been asking for the plot of land which has been enclosed by the Panchayat authority, and my lord, there is sought for direction upon the Panchayat authority to make, my lord, the remove the portion which has been encroached by the Panchayat authority. There was a pond recorded as a pond, and after the, my lord,
Where is the record of right?
record of right, my lord, kindly come to page. Page, my lord, come to page 60. Page 60 starts from page 59. 58, 59, and 60, the record of right. Debabrata Chakraborty is my client.
Yes, yes.
So that record of rights has been corrected.
Record of rights has been corrected, my lord. It was, my lord, revealed in the predecessor. Thereafter, their name has been recorded that as a riot. That is the plot number, my Khotia number 1816. His father's name is Nityanando. 100 decimals of land, my lord, has been recorded. Thereafter, page 61 shows there are the several other, my lord, persons, my legal heirs has been recorded. All the, my lord, the land is possessed by the petitioner, and thereafter, my lord, it has been, my lord, the Panchayat authority has been used as a village path. When it was, my lord, the pond, when it was, my lord, the extended the embankment has been, my lord, lost. Thereafter, this my land has been used as a village path. So this petitioner asks for, my lord, the verify your by the land by the PLR or the concerned PLR whether the land, if it is enclosed, then the compensation may be, or otherwise, my lord, it has been removed the Panchayat path from my land. This is the allegation of the petition.
You have any report with you?
I do not have any report, my lord. Report is required for this sides.
Learned advocate for the petition, affidavit service filed on behalf of the petition is taken on record. Learned advocate for the petitioner submits that the Panchayat authority, namely respond number 2 and 3, have made constructed road over the Vastu land belonging to the petitioner without any acquisition and payment of compensation. He seeks for appropriate direction upon the authorities to remove such encroachment and pay adequate compensation. Mr. Jayanta Samanto, learned advocate for the state, submits that there is suppression of material facts in the writ petition. Previously, the petitioner moved a writ petition praying for correction in the record of rights. which has not been disclosed. He seeks to file a report. Let such report be filed within a period of 1 week,
2 weeks,
2 weeks. Reply if any, 1 week. The matter is returnable motion here. After 3 weeks. Careful. Keep going.
Lalita.
কাগজ আছে? ঠিক আছে। Petitioner is appearing. Who is for the petition?
Shabir Ahmed, your lordship.
It's not appearing.
He has completed his argument.
But his presence is necessary.
My lord.
Someone at least from his team.
You have concluded.
My lord?
You have concluded.
No, I have not concluded. I have just introductory. I have. My lord,
You have
this
filed
is-
your written.
My lord?
You have filed your written notes.
My lord, one note, my lord, that is the, my lord, I have formulated how this petition, I shall, is not maintainable, how will, my lord, advance my argument. And there are, my lord, at least, my lord, since 1952, all the judgments I have made a compilation.
Okay.
And I will place the relevant
Can you
paragraph.
inform him?
Sorry.
I'm just. And also my written notes have been placed. They are on record. But still, few judgments, our High Court, during the pendency of these panchayat elections, whether these writ petitions are maintainable or not, a very lengthy and judgment was given by our division bench. That I will place before your lordship.
Particularly the maintainability is, my lord, is to be considered first.
First. And also, there is a provision in law that inform that if during the process of nomination, if an objection comes up, there is a process called scrutiny. If there is no objection, then only it is going to be heard during that election petition. Then you are not supposed to, because after nomination, a period of 7 days gap is given where the parties, their agents, all are supposed to scrutinize the applications who are to contest the elections. And during that time, if you have an objection, you have to raise before the concerned officer. If during that time it is not raised, then election petition is the only remedy which lies. I will take lordship to those sections also.
Section
Ari, she's on her way. She's coming.
Please start corner.
Yes, start. Our division bench lordship first I will show.
আমি পুরোটাই বলবো। আমাদের এটা একটা
কি ফাইল করেছিল অল্টারনেটিভ এটা দেখুন তো কে ফাইল করেছিল ইস্যু ওয়েদার ইট ক্যান মেইনটেইন এখানে তো ফাইল
Lordship, may kindly take this copy. Nimaira.
ইমেলটাই বলতে আমাদের কাছে নেই।
Your respondent number?
Yes. I was the appellant in this matter, your lordship, which was before the division bench.
Yes.
Nimaira is the judgment which I will rely upon. It was passed by our Honorable Division Bench, which was presided over by Honorable Justice Arijit Banerjee and Prasanjit Bishwas. Now, Your Lordship, the relevant paragraphs. Kindly seize the first paragraph. This appeal is directed against a judgment and order dated 27 September 2023, passed by a learned judge of our court in WPA 16880 of 2023, being a writ petition filed by the respondent numbers 1 and 2 in this appeal, namely Nimairai in short Nimai and Bibi Najira in short Najira. The present appellants were the respondent numbers 1 and 2 in the writ petition. By the judgment and order impugned, the learned judge rejected the decision of the State Election Commission not to recount the ballot paper. This was the principal grievance, and this was the prayer which was before the learned single judge. Not to recount the ballot papers in respect of the Panchayat election in question, and directed the Commission to recount the ballot papers which stood rejected on the ground of defect on the part of the presiding officer in not inscribing his signatures and not affixing the distinguishing rubber seal on the reverse of the ballot papers. The respondents, writ petitioners, approached the learned single judge with the following case. They were the contesting candidates of the All India Trinamool Congress in the Devipur Gram Panchayat in the West Bengal Panchayat General Elections 2023. They contested the election from Devipur/A7H constituency of the Devipur Gram Panchayat. The seat numbers on which they contested were 8 and 9 respectively. The election took place on a scheduled date, that is the 8th of July 2023. It was a peaceful election held in free and fair manner. The total number of ballots used was 1093. The counting started at the scheduled time on July 11, 2023 in the presence of the writ petitioners and their agents. However, during the process of counting, disproportionate numbers of ballot papers, being 758 and 752 respectively, be declared as invalid, and the corresponding votes were cancelled. On inquiry, the writ petitioners came to know that the rejected ballot papers did not contain the seal and signature of the presiding officer and hence were discounted. The petitioners pleaded with the counting officials that since the vote was held peacefully and the true mandate of the electorate had been captured on the ballot papers, simply because of some laches or default on the part of the presiding officer, the concerned ballot papers should not be rejected. Such request was in vain. At the end of the counting, it was found that the candidates were declared winners in respect of two concerned seats, won by a very narrow margin of only a few votes. It is not only in the interest of the petitioners, but also for the sake of democratic principles that the issue should be probed into in detail by the intervention of the Constitutional Court under its all-encompassing and extraordinary writ jurisdiction, preferably by some stoically neutral agency under the supervision of the court. With the aforesaid pleadings, the writ petitioner approached the learned single judge praying for the following reliefs. A writ of in the nature of certiorari calling upon the respondents and each of them to transmit the records of the case to the Honorable Court so that the Honorable Court may certify the same and do consignable justice to the case by quashing the decisions arrived by the State Election Commission in respect of Devipur/8 and 9 Gram Panchayat seats in the Panchayat General Election 2023, particularly the results so announced. A writ in the nature of mandamus directing the state authority to conduct the audit of the ballot papers. A writ in the nature of mandamus directing the State Election Commission to order a recounting after taking into account all the ballot papers which are otherwise valid, but for the absence of seal or signature of the presiding officer. A writ in the nature of mandamus directing the State Election Commission to order recall if necessary. When the writ petition was moved by an order dated 19/70/2023, the learned single judge called for a report in the form of affidavit from the State Election Commission and the Panchayat returning officer apropos the allegations made in the writ petition. Such report was filed and the allegations made in the writ petition. Writ petitioners filed their exception thereto. Before the learned single judge, it was argued on behalf of the writ petitioners that the sole purpose of conducting the election is for ascertaining the mandate of the electors. In the present case, the mandate of the electors could not be ascertained as most of the votes stood rejected on the ground of deficiency on the part of the presiding officer who failed to put his signature and the distinguishing mark on the reverse of the concerned ballot papers. The electors were not at the reverse of the fault which warranted rejection of their votes. An election where votes of majority of the electors are rejected for no shortcoming or error on their part cannot be treated as mandate of the electors. Such an election is an empty formality. There should be repolling or at least recounting on the votes taking into consideration all casted votes. On behalf of the Election Commission, it was submitted that no objection was raised by, on behalf, or the writ petitioners at the time of counting. Even there is a provision of law, Your Lordship, that during the time of counting, if you have an objection, you can raise it with the presiding officer relevant at that point of time. That also I will quote when I will be taking Lordship through the Panchayat Election Act. Therefore, there is no scope of recounting for the votes. The point of maintainability of the writ petition was also urged on behalf of the State Election Commission. In reply, it was submitted on behalf of the writ petitioners that despite their best efforts, they could not lodge their objection at the time of counting of the votes since they were mercilessly beaten up and thrown out of the counting center. The learned judge noted from the report of the State Election Commission that it was not agreeable to recount the rejected ballot papers since there is no provision for the same in the 2003 Act or the 2006 rules. Any decision to reopen counting may have a disquieting effect on the forthcoming elections. The Commission, being a constitutional body, would like to continue discharging its duties as envisaged under the extant acts and rules. The learned judge held that the Election Commission ought to have relied upon and invoked the proviso to Rule 82H of the West Bengal Panchayat Election Rules 2006, which prescribes that where a ballot paper is defective on account of any mistake or failure on the part of the presiding officer or the polling officer, the ballot paper shall not be rejected merely on the ground of such defects. The learned judge observed that when the margin of the successful candidates in the two seats is so minimal, the Commission should have taken a decision to recount the rejected votes. The learned judge disposed of the writ petition with the following observations and directions. The basic principle is that the mandate of the electors has to be given prime importance by counting their votes and not by rejecting their votes on the ground of any defect on the part of the presiding officer or the polling officer. The Commission, being a constitutional body, ought to have acted in accordance with the Act and the corresponding rules upon proper application of mind and ought to have acted mechanically so as to frustrate the very purpose of the election. The Commission ought to have applied the law in a positive manner so that the election is seen to have been conducted in a free, fair, legal, and proper manner. Assuming that complaint was not lodged in proper time, records reveal that it is only because of the defect of the presiding officer that the vote stood rejected. The Commission ought to have taken appropriate steps against the presiding officer who failed and or neglected to act in accordance with the guidelines prescribed by the Commission and for whose defect the legal complication arising out of rejection of votes arose. The Commission ought to follow the rules as well as the mandate of the people, relying on vote the democracy is run. The issue of maintainability as raised by the Commission cannot be accepted in view of the decision of the Honorable Supreme Court in the matter of Union Territory of Ladakh versus Jammu and Kashmir National Conference 2023 SEC Online SC 1140, wherein the court observed that election to any office body is required to be free, fair, and transparent. Elections lie at the core of democracy. The authority entrusted by law to conduct such elections is to be completely independent of any extraneous incident consideration. A just cause ought not to be frustrated by effects of time. In view of the above, the decision of the Commission refusing to permit recounting of the ballot papers cannot be accepted by the court. The Commission is directed to recount the ballot papers which stood rejected on account the defect on the part of the presiding officer in not inscribing the signature and not affixing the distinguishing rubber seal in reverse of the ballot papers. The recounting shall be conducted at the earliest but positively within a period of 3 weeks from the date of communication of this order. Being agreed, the State Election Commission and the commissioners have come up by way of this appeal. Appearing for the appellants, the learned senior counsel made submission only on the point of maintainability of the writ petition. Learned counsel submitted that in view of the bar in Article 243(o) of the Constitution of India, the writ petition ought not to have been entertained by the learned single judge. The only remedy that the writ petitioners had by way of an election petition before the prescribed forum. Learned counsel referred to the following two decisions of a concurrent bench. Judgment and order dated July 3, 2023, rendered in MAT 1165 of 2023, West Bengal State Election Commission versus Shushanto Pramanik. Judgment and order dated April 2024, rendered in MAT 1654 of 2023, Block Development Officer versus Surajit Pramanik. Learned Senior Counsel submitted that he was not citing the relevant Supreme Court decisions, since such decisions had been considered and discussed in the aforesaid judgments of this court. Learned, আপনার copy আছে? আমি দিচ্ছি, নেই মাইরা? Learned Senior Counsel submitted that he was not citing the relevant Supreme Court decisions, since such decisions had been considered and discussed in the aforesaid judgments of this court. Learned Advocate appearing for the respondents, writ petitioner, submitted that the writ court has plenary powers. The power is limitless in spite of the provisions of Article 243O of the Constitution or the provisions of the West Bengal Panchayat Elections Act 2003. The High Court can entertain a writ petition wherein gross irregularity in the conduct of a panchayat election has been brought to the notice of the court. The restriction on the High Court entertaining such a writ petition is merely a self-imposed one. It is akin to the self-imposed petition. It is akin to the self-imposed restriction whereunder the High Court normally refuses to entertain a writ petition when alternative remedy is available to the petitioner. The writ petitioner, Learned Advocate, submitted that the High Court's power of judicial review under Article 226 cannot be curtailed. Now, at paragraph 14 also, your lordship deals with a particular judgment. I'm just underlining the relevant part. Third line, your lordship. Therefore, a writ petition is maintainable. In this connection, Learned Advocate referred to a decision of the Honorable Supreme Court in the case of Assistant Commissioner of State Tax versus Commercial Tax SC Limited, 2021 SEC Online SC 884. Learned Advocate relied on paragraph 11 of the reported judgment, wherein it has been observed that the existence of an alternate remedy is not an absolute bar to the maintainability of a writ petition under Article 226 of the Constitution. A writ petition can be entertained in exceptional circumstances wherein there is a breach of fundamental rights, a violation of the principle of natural justice, an excess of jurisdiction, or a challenge to the virus of statute or delegated legislation. What I'm trying to apprise your lordship about, that in all the paragraphs 14, 15 onwards, the learned division, honorable division bench of our High Court has just tried to ascertain that alternative remedy. The last paragraphs, the few last paragraphs, goes on to only suggest that if an alternate remedy is there in the Panchayat Elections Act 2003, then writ jurisdiction under extreme circumstances only needs to be exercised. Otherwise, the existence of alternative remedy is there. The petitioner ought to have been over there, and there is a constitutional bar under 243O. If lordship allows, I can go through all the paragraphs of this judgment, or I can straight away take your lordship to what Article 243O of our Constitution says.
No, what is the ratio laid down in?
Ratio, last few paragraphs. Kindly see paragraph 19. Lordship can come to paragraph 17 also, court's view. Has your lordship got it? There is no doubt that free and fair elections must be ensured for proper functioning of a democracy like our country. The need to maintain the purity of the election process cannot be overemphasized. All citizens who qualify to contest an election must be permitted to do so by filing nomination papers. All members of the electorate must be allowed to exercise their franchise freely and by casting their votes in favor of the candidates they choose. All returning officers must act fairly and in a completely impartial manner. The provisions of law, including the rules framed under the relevant statutes, must be scrupulously adhered to by the officers who are in charge of conduct of the elections. In other words, an election process should be completely transparent and in no manner should be biased in favor of any of the political parties. 18. However, the question is otherwise. If a contesting candidate or any other person having locus standi to challenge an election process wishes to do so, which is the forum that he should approach? Can such a person approach a civil court or the writ court exercising jurisdiction under Article 226 of the Constitution of India to agitate his/her grievance regarding the conduct of the election proceedings? The answer is clearly in the negative. Our Constitution itself has provided that an election dispute must be brought only before a special forum to be prescribed under the state laws. Insofar as panchayat elections are concerned, Article 243O of the Constitution reads as follows. 243O. Bar to interference by courts in electoral matters. Notwithstanding anything in this Constitution, A. The validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies made or purporting to be made under Article 243K shall not be called in question in any court. B. No election to any panchayat shall be called in question except by an election petition presented by to such authority and in such manner as is provided for by or under any law made by the legislature of a state. 20. In compliance with the constitutional mandate, the West Bengal State Legislature promulgated the West Bengal Panchayat Elections Act 2003. The West Bengal Panchayat Election Rules 2006 have been framed under the 2003 Act. Section 79, 80 and 93 of the 2003 Act read as follows. Section 79. This was the relevant section which I was trying to show your lordship, but it is in the judgment itself. 79. If any dispute arises as to the validity of an election under this act, any person entitled to vote at such election may, within 30 days after the date of declaration of the results of such election, file a petition calling in question such election on one or more of the grounds specified in subsection 1 of section 93 and section 94 before the civil judge having jurisdiction where such election is in respect of a gram panchayat or a panchayat samiti. B. Before the district judge of the district where such election is in respect of a Zilla Parishad or the Siliguri Mahakama Parishad. 2. When filing a petition under subsection 1, the petitioner shall deposit in court as security for the costs likely to be incurred 500 rupees where the petition is filed before the civil judge. B. 1000 rupees where the petition is filed before the district judge. 3. Every petition shall be accompanied by this is the process which has been laid down.
Yes.
Then 80. Next page. No election petitions to panchayat shall be called in question by an election petition presented in accordance with the provision of this part. 93. May I read it?
Yes.
Grounds for declaring election to be void. Subject to the provisions of subsection 2, if the court is of the opinion that on the date of his election, a returned candidate was not qualified or was disqualified to be chosen to fill the seat under this act, that any corrupt practice has been committed by a returned candidate or his election agent or by any person with the consent of a returned candidate or his election agent, that any nomination has been improperly rejected, that the result of the election insofar as it concerns a returned candidate has been materially affected by the improper acceptance of any nomination or by any corrupt practice committed in the interest of the returned candidate by an agent other than his election agent, or by the improper reception, refusal, or rejection of any vote, or by the reception of any vote which is void. 4. By any non-compliance with the provisions of this act or of any rules made under this act, the court shall declare the election of the returned candidate to be void. If, in the opinion of the court, a returned candidate has been guilty by an agent other than his election agent of any corrupt practice, but the court is satisfied that no such corrupt practice was committed at the election by the candidate or his election agent, and every such corrupt practice was committed contrary to the orders and without the consent of the candidate or his election agent, that the candidate and his election agent took all reasonable means for preventing the commission of corrupt practices at the election, and that in all respects the election was free from any corrupt practice on the part of the candidate or any of his agents, then the court may decide that the election of the returned candidate is not void. 21. The law is now well established that any election dispute insofar as panchayat elections in the state are concerned must be resolved by the forum prescribed under the 2003 Act. Jurisdiction of the civil court or the writ court under Article 226 of the Constitution cannot be invoked by an aggrieved party in that regard. There are some decisions of the Honorable Apex Court which are to the effect that there is no bar of a writ court entertaining a writ petition regarding election disputes, since the jurisdiction of the Supreme Court under Article 32 and the jurisdiction of the High Courts under Article 226 cannot be ousted or abridged by legislation. However, these decisions also clarify that as a matter of course, in connection with election disputes, the writ jurisdiction under Article 32 or Article 226 of the Constitution will not be exercised by the courts in view of availability of an efficacious alternative remedy before a special tribunal or a special forum. Paragraph 22. N.P. Pannuswamy is a very famous judgment related to elections. This AIR, the Honorable Supreme Court. I'm reading from the third line, Your Lordship, after the citation. The
It's not
Honorable
required.
Supreme Court.
You see, it's not required.
Yes.
Next is,
Yes.
which is the other decision?
Every paragraph has a judgment, Your Lordship, which our division bench has.
33.
33, then I'm straight away taking Your Lordship to that what was the ratio as Lordship had asked me. In view of the aforesaid, this appeal must succeed. The learned judge should not have entertained the writ petition. The order under appeal is set aside. The writ petition is dismissed as not maintainable. We have not expressed our opinion in the merits of the writ petitioner's grievance as ventilated in the writ petition. They will be at liberty to pursue the statutory remedy that is available to them in accordance with law if they are still entitled to do so. The appeal and the connected application stand. So this is the most recent judgment when the panchayat elections concluded and many writ petitions were filed and a few of them were also before the division bench. This division bench judgment dealt with all the judgments formulated by by many courts, and each and every paragraph, most of them which I have apprised your lordship of, only our division bench held in the concluding paragraph, paragraph 33, that if an alternative efficacious remedy is available, which is section 79 and 80 of the Panchayat Election Act 2003, then writ petitions are not maintainable. This is my humble submission. To that effect, I have also submitted a written notes of argument when the determination was before Honorable Justice Ravi Kishan Kapoor. I have already filed, if that is on record. Otherwise, because as far as I remember, I had already submitted my written notes of argument, which I have dealt with Moninder Singh Gill.
President Mohinder Singh Gill, yes.
Yes, I have already submitted, and this judgment, our division bench, I have handed over a copy to your lordship today.
Okay.
My humble submissions before your lordship is that when an alternative efficacious remedy is available, which is section 79 and complete bar under 243(o) of the Constitution of India, which says that if there is an alternative remedy, there shall be no interference from any court. So with these 2 points, very humbly I have beseeched your lordship. These are my short submissions, and if Mr. Ahmed wants to reply,
Already I have given the notes, my notes. I have formulated the issue relating to the maintainability, the constitutional provision. I have placed, perhaps in short, I have placed the issue whether each writ petition is maintainable.
No, it is here.
Is maintainable after issuance of election notification. Prayer for declaration of the result of election is void. Prayer for recounting after declaration or result and or consequential relief challenging the election and or maintainability of the writ petition wherein representation was made by the parties, party president, secretary, and not by the contesting candidates, and claiming irregularity committed during the process of election and out of the result or in the alternative in all election dispute. Well, these are the short questions. I have tried to, my lord, argue. The, my lord, article 243K I have, my lord, quoted here. 243O I have quoted. But to interference court in electoral matters, notwithstanding anything in the constitution. The validity, my lord, the next, my lord, the B is the relevant. No election to any panchayat shall be called in question except by an election petition presented to such authority and in such manner as is provided for or under the law made by the legislature of a statute. But this is the constitutional provision. Now, my lord, the relevant the statutory provision. I have, my lord, note down the which are the relevant acts and rules. Now, section 80. Section 80 says that no election petition to Panchayat shall be called in question except by an election petition presented in accordance with the provisions of this part. 19.3, these are the grounds on which election petition can be made. On the date of his election of a written candidate was not qualified or disqualified. This was tried to be sought for by the petitioner that relating to his caste certificate, OBC certificate which was given, he complains of some irregularity, and that is also covered under this act. That the date of election of a returnable candidate was not qualified or disqualified. His OBC certificate, but his argument was that his OBC certificate is irregular. In that event,
Yes.
in that event, my lord, his election is void. This point is also under the election dispute. Next, any corrupt practice, any nomination, the result of election, improper acceptance of any nomination. Improper acceptance of any nomination, it is also includes. Improper reception, refusal or rejection of any vote and other reception of any vote which is void. That is also. Everything relating to election after the issuance of notification is the election dispute, and that should be challenged by way of a election petition. And my lord, I have given the page 4, my lord, the notification, what were the dates, and also quoted the rules which are the counting, in which provisions countings are made, rules 83 to 95, 92, 6 to 98. Well, these are the election provisions, election rules. These are, my lord, and the notification I have annexed the notification, my lord, that is election date which has been fixed 15th June 2023 is the date of last date of making nomination. So after 15th June, if any petition, writ is not maintainable.
When was this writ petition filed?
My lord?
When was this filed?
The writ petition was filed, affirmed, it is affirmed on
Yes. 4th July.
My lord, July.
Coming under the section.
It is, my lord, 3rd day of July. So last date is 15th June, when the notification election disputes, it is election. And my lord, so and another thing, my lord, if his challenge is to be said, the irregularities in the issuance of OBC certificate, then there is also others act, others provisions. Scheduled caste and tribes and others backward class commission act section 8, there is a provision of appeal. I am not going to it. I am only in the question of maintainability of the writ petition. My lord, for your lordships, my lord, kind consideration, my lord, have the annexures are given in support of the contents of the judgments I have referred. Is there on in the notes?
No. It is
My lord, kindly don't note to the. Don't note to the judgment. এই জাজমেন্ট গুলো আমি দিয়ে দিচ্ছি এবারে এটা একটু দিয়ে দিন তো My lord, I am only mentioning the and I am giving the bunch, my lord, the compilation. First of all, my lord, 1952 Supreme Court, that has been considered also in our High Court, every High Court. That is the Punnuswamy case. This is the famous First election case, it is by 6 judges bench. Now paragraph 7, 8, 12, 13, 15, 16 and 26. I have noted down. Thereafter, my lord, Mohinder Singh judgment. It is also 5 judges bench. My lord,
Sorry, it is there. Sorry. It is there.
It is there.
Yes.
Mohinder Singh Gill's judgment. And paragraphs are 24, 79, 92, 94, 102, 107, 123, 126, 127. These are the relevant paragraphs, and the 5 judges bench held the election petition is not without election petition. 226 is a totally barred, or the article 32 is also barred. Now 2005 8 HC, it is 2 bench judges. Well, paragraph 16, 17, 18, 22, 23, 24. Next, 4, 2018, 10, 2018, 18 SCC, page 141. 3 judges bench. This is the famous case. The West Bengal State Election Commission and other versus Communist Party of India 2000 Marxist. Here the after 2000 election, there was an allegation that a large number of seats were uncontested. Almost 30% seats were not, there were no election. Then whether it will be maintainable or not, that question come into consideration, and it went to the Supreme Court, and the Supreme Court held no 1 month time given to the petitioners, that is Communist Party of India and others, to file election petition. Only 1 month time was granted, no other relief. The relevant paragraphs are 17, 26, 30, 31.
You are correct. 26, 27, 30, 31.
My lord, it is 26, 17. It would be first 17 would be.
In my copy, it is 27.
My lord, it would be, my lord, 17.
No,
No. It is 17. 7. Now, civil appeal, my lord, that is single bench arising of SLP Lakshmi Bai and collector Nanded, paragraph 37, 38, 40, 42.
You give a copy of this decision.
My lord, I shall give all the judgments in the compilation sheet. This is the bunch, my lord. All the judgments are there, my lord, which I have referred to.
Okay.
Now the writ petition, my lord, that is Justice Dipankar Datta was one of the judges, my lord. It is here. Writ petition is in Bombay High Court. Whether the rejection of nomination fraud would attract the provisions of Article 243 OB of the Constitution. And there are several paragraphs. Page number 3, my lord, it is several paragraphs. 4, 7, 9, 15, 16, 17, 18, 19, 23, 27, 28, 29, 30, 33, 34, 36, 37, 38, 39, 41, 42, 3, 46, 50, 51, 54, 55, 56, 57, 60, 62, 63, 68. Then, my lord, one of our another division bench, the block development versus Surojit Pramanik. This is the similar type of judgment by Justice Orijit Banerjee, presided over.
Yes.
Paragraph 5, 7, 9, 10, 11, 13, 14, 15, 22, 23, 24, 25, 28. Same ratio. Now, my lord, I have কি এইটার কপি দেওয়া যাবে না পিটিশনের না এটা
The other decisions you were referring to in Sushanta Pramanik, that judgment.
Surajit Pramanik.
This is
No,
the judgment.
Oh,
Surajit Pramanik.
In which in our division bench judgment which I handed over, this judgment only is there, which my learned senior friend is referring to.
Now, my lord, another Supreme Court case, that is, my lord, I will place only one paragraph here. 1988 4 SCC, page 534. If your lordship kindly see the last judgment, I have annexed here, paragraph 13. হ্যাঁ ভরত সিং
yes.
Age has been already noticed, although the point age to profiteering by the state was pleaded in the petitions before the High Court as an abstract point of law. There was no reference to any material in support thereof, nor was the point argued during the hearing of the writ petition. Before us also, no particulars, no facts have been given in the special leave petitions or in the writ petitions or in the affidavit, but the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by the HSIDC. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such fact by evidence which must appear from the writ petition. If he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain that point. In this writ petition, nothing has been pleaded or nothing, but subsequently, after our report in the form of affidavit, he has tried to substantiate some documents, some councillor certificate, everything were taken. In the writ petition, no document, no clear averment. In this context, it will not be out of place to point out that in this regard that there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plaint or written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed to it. I am, my lord, emphasizing these lines of the apex court. So this point has to be raised before us by the appellant is not entertainable.
Yes, that's all.
And my lord, in fact, my lord, this is the purely disputed question of fact. It should have been considered by evidence and witnesses before the trial court. And unless it is the trial court there is taking evidence, the election cannot be, my lord, set aside or set at naught, or any relief.
Okay. And what about the decisions that has been cited on behalf of the petitioner? Resurgence India and other is
another Ladakh.
Anup Baran 1.
Onu Baranwal. Onu Baranwal is the, my lord, the decision, my lord. I am distinguishing the case. Onu Baranwal is the case. Here is the selection of the election commissioner, not the election by people franchise. Selection of the election commissioner, that is why the apex court had entertained. That is the selection of election commissioner, not any elected body by people employed, people franchise like Panchayat, Panchayat Samiti, municipality, MLA, MP, by direct vote of the people. Onu Baranwal. Another is Ladakh. I have Ladakh has already been the division bench has taken into consideration.
And Resurgence India, the other decision, para 11 and 22.
না রিসার্জেন্স যেটা তো খেয়াল করা হয়নি হ্যালো ওটা সাইটেশনটা হোয়াট ইজ দ্য সাইটেশন
2014 volume 14 SCC 189. 2014 volume 14 SCC 189.
20. My lord, I will take 5 minutes tomorrow, my lord, that to distinguish that judgment.
Okay.
14 SCC page
189.
189 paragraph
11 and 22 he has referred to.
11 and 22.
Okay.
Onu Baranwal is, my lord, I have distinguished that the Onu Baranwal is not applicable here because that is the selection of the election commissioner, not the election by public franchise.
Yes.
Public franchise. My lord, I will take only 5 minutes. My lord, before my learned friend will reply, perhaps he will give the reply. Kobe David.
Next. Next day, my lord. My lord.
That means tomorrow or?
Tomorrow, my lord.
Tomorrow will file your written notes.
Yes, my lord.
Sure. Okay then. This one
আমাদের নামগুলো আছে সব নমিনেশনের ক্ষেত্রে
concludes her argument. On behalf of the state responsible concludes his argument. Motion is sought for yes.
Another unreported decision. Well, Sanjay Mondal, here several appeals were relating to the rejection of the nomination paper. All with same view have been held. এটা ওটা সঞ্জয় এমএটিটা দিয়ে দাও সঞ্জয়ের এমএটিটা হ্যাঁ হ্যাঁ কোনটা সঞ্জয় তো হ্যাঁ এই এমএটি নাম্বারটা নিয়ে নে তো এটা রিপোর্টেডও আছে 2023 3CHN page 565
What are the relevant paragraphs of the decision?
Well, here all the points has been discussed and ultimately, my lord, the last paragraph is the conclusion. Here the 243O, everything has been 79, everything has been discussed. My lord, paragraph 20 is my lord, the conclusion. The ratio in view of the order under appeal cannot be sustained in law and is set aside. Needless to say, respondent petitioner will be at liberty to will be free to exercise their right under section 79 of the West Bengal Panchayat Act. আচ্ছা এগুলো নেই এখানে আছে কিনা জানি ওখানে আছে কিনা না 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 CHM 2023 3CHM
On behalf of the petitioner to file
এটা কি আর ওই জয়মাল্য বাগচি
the written note of
এই
argument.
জয়মাল্য বাগচি ডিভিশন দিবি
ঠিক আছে Place this matter on.
জয়মল একটা
ওইগুলো মনে হয়
জয়মল ও দরকার নেই। ও
Friday যাবো।
একটাতেই
My lord,
Wants to take time.
Yes,
my lord, kindly take 2 days time, my lord, for
ঠিক আছে সেটা তুমি বলো।
when
2 days. Thursday.
can you
Thursday, my lord.
conclusion by Friday?
Thursday.
Friday.
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 ঠিক আছে।
না আমাদের কোনো আপত্তি নেই, আমরা এসে যাবো।
How you conclude and
My lord, next Monday, my lord.
Monday. Where is Mr. Samim?
জুনিয়র ইজ হিয়ার।
Take proper instruction.
Yes, my lord.
Is he ready with the written notes to file on Monday?
Monday, my lord. Monday, my lord.
শনিবার রবিবার সময় পাবে মানডে।
Monday, 7 July.
But I will take only 5 minutes my lord to distinguish that judgment.
8 July ko.
আরে ঠিক আছে।
Any.
Grateful, your lordship.
Thank you.
এই যে জাজমেন্টটার পরে আমাকে দিয়ে ওটা একটু বাড়ি নিয়ে যাবো।
2014
তোমার বাড়িতে
হ্যাঁ শেষ করে দেবো। 7th কিছু আছে কি?
5 মিনিট।
হ্যাঁ 7th আছে? সেটাকে রাখো, টপে রাখো, শেষ করে দেবো।
Lordships, I am appearing on behalf of the petitioner. Petitioners came before your lordship for compassionate appointment.
My lord, Mr.
Please.
For compassionate appointment.
Mr. Shofik Dian is appearing due to illness. He is not came today court.
Despite sufficient
Kindly make it not today.
the name of the petitioner was recommended with his letters as a prayer for the has been turned on the ground of delay. Oh, this was the case where the recommendation was made, but subsequently it has been
But
turned.
I am actually the respondent authority, the assistant secretary relied upon the subsequent circular and rejected my pair. But law has clearly stated, if the employee dies in hardness, the circular may be applicable on the date of death or before the date of death. If the circular is not applicable to the petitioner's case, that is the assistant secretary relied upon the circular. 2000 petitioner died 2011 and they relied upon the circular 2013 and 16. I put in question before your lordship, if the circulars are not available on the date of death, after the date of death, the circular is not applicable to the petitioner's case. Therefore, I am relying this judgment, Supreme Court and also my High Court judgment, several judgment. If the circular is not applicable, therefore the contents of the said circulars are not applicable. Yes. My lord, this is single bench judgment. My lord, Honorable Justice Devashish Korgupta.
Paragraph.
Writ application filed by the petitioner against the impugned order passed by the respondent authority rejected the pair of the petitioner for appointment on compulsion ground. The court held that the number of the dependents of the disease assistant teacher cannot be the deciding factor for the considering the claim of the dependent of the disease employee to get appointment on contract ground. The contention and decision of the authority concerned is improper, malified, misconceived, and not sustainable in the eye of law. The writ application stand disposed of by the directing the respondent authority to give appointment to the petitioner on compulsory ground with a period of 2 months. Totally clear stated. Then, my lord, division bench judgment.
কালকে নট টুডে ওপরের দিকে রাখুন tomorrow talk
Yes, I'm grateful.
tomorrow he'll come
Tomorrow he will come.
great
Repeating হচ্ছে 20 March 2014 1 CLJ অনেক জাজমেন্ট অনেক আছে সেভার হাইকোর্টের 6খানা জাজমেন্ট ডিভিশন বেঞ্চের সুপ্রিম কোর্টের 5খানা জাজমেন্ট যে যদি if the person died in hardness on death the circular may be applicable is applicable on the before the date or the date of death. After the date of death, the circular is not applicable. Petitioner died 2011 and they rely upon the circular 16 and 13. This is my case.
Item number 1 to 6 was very short matter.
1 to
6 of today's this were returnable. It is on the top. Well, actually, 26. But the boy by getting his job only on the ground that on the date of appointment he was 2 years, 2 months less than 25 years. But there is a judgment.
Mathematics teacher.
Mathematics teacher. But each and every day he is coming, his family is suffering. His only child is reading in class 8. He is not in a position.
Date daw jo
And my lord, Mr. Sarvajahan is for the Madrasa Education Board. He is to be informed. I am appearing with the state.
But kindly fix a date for that.
you give a notice to Mr.
Yes.
Mr. You are for the
I for the state.
He is my friend. He will not have.
and Mr. Jahan is not here
Mr. Mahan is my friend.
কালকে থাকে
120 দেখো বলো নেক্সট উইকে বলে দাও
কিছু বলার নেই তোমার সার্কুলার আছে সুপ্রিম কোর্ট হাইকোর্টে জাজমেন্ট আছে
কোথায় আপনি বলছেন ওনারটা একটা ডেট ফিক্স করে দাও এটা কবে আসবে না ওরকম করে বলো যেরকম আছে থাকে বাকিগুলো এতে থাকবে না টাইটেতে হিয়ারিং এ দিয়ে দেবো ওইটা হ্যাঁ হিয়ারিং এ কি আছে ওটার পরে দিয়ে দেবো হবে কবে দেবো সেটা বলো না নোটিশটা দিতে পারবে নোটিশ দিতে হবে আফটার ওইটা রিপ্লাইটা দেবে 119টা মানডে গেছে তো এটা পরে দিয়ে দাও on 7th July
7th July.
second item
My lord, the next matter 121, my lord, the state had to file a report. My lord, I don't know whether they are ready with the report because I have not been served with any of the things. My lord, they have not filing the
take
file.
it up tomorrow please
So, my lord, if they are not filing the report, my lord, then kindly grant them an
Report is there.
Then
My lord, 129, my lord, in this matter also, my lord, against the unauthorized constructions, my lord, we have filed this petition. My lord, the state government, I am learned advocate appearing for the state, my lord, they have served me the report, my lord. But taking advantage of the pendency of this matter, my lord, the respondents are continuing private
after
respondents.
2 days you mentioned let us see how the top goes there are so many
Actually, my
top
lord, before summer vacation, my matter was after 3-4
let it be
matters
there.
under the heading
Let us see how
returnable
it
motion.
goes, huh?
But now, my lord, I
I
find, my
will upgrade it tomorrow let us see how the top
Gosh.
goes
very well.
Can I request my friend to serve a copy of the report so that I can ascertain whether the next
এই জাজমেন্টটা ওনাকে দিয়ে দাও tomorrow চলো থ্যাংক ইউ
A grateful.
I am grateful.